Hi, good afternoon. My name is Jenny Faubert, and I'm the Editor-in-Chief of Career Education Review. I want to welcome you to our sixth and final webinar for 2014, the Department of Education's Gainful Employment Final Rule, Key Components and Compliance Considerations. Today's webinar is presented by Peter Layton, Catherine Brody, and Steve Chema of Ritzert and Layton. Before we begin, I just want to tell you a little bit about CER. As you may know, we are published twice a month and cover a wide range of topics, including school operations, student retention, public policy, compliance, and placement, just to name a few. In our November issue, we had an interview with Daniel Greenstein from the Bill and Melinda Gates Foundation. We thought his thoughts on the for-profit sector were particularly interesting and probably not what we all expected, so that was an interesting article. In our current issue, which is the December issue, we did an interview with Harry Alford, who is the president and CEO of the National Black Chamber of Commerce. He discussed why he disagrees with gainful employment, so that was another interesting interview we did that's in this current issue. And then in our upcoming January issue, where we're focusing on human resources, we have an article written by Tom Foster, who is the author of Hiring Talent, Decoding Levels of Work in the Behavioral Interview. So that's just a little bit of what's going on with CER right now. If you are interested in finding out more information, just feel free to contact me. Now, to answer a few questions before we begin, the webinar will be recorded and available on the CER website along with a PDF of the webinar. Tomorrow, you will receive an email with all of that information and a link to that information. If you're having any technical issues during the webinar, please send me a message through the chat function, and I will try to answer that right away. Also, if you have any questions, please feel free to submit those questions in the question feature. We'll save 10 to 15 minutes at the end for questions. Now, if we receive more questions than we have time to answer, what we will do is send an email out with answers to everyone's questions. So I want to thank Peter, Catherine, Steve, and the rest of the team at Ritzert and Layton for their continued support of Career Education Review. And I'll now go ahead and hand it over to Peter.
Thank you, Jenny, and good afternoon to everyone who has dialed in. First, I do want to thank Jim and Jenny and Career Education Review for working on this series of webinars with us. I think it's been enjoyable for us and very productive, I hope. Today's seminar is on important new regulation, which has gotten a lot of publicity, both positive and negative, and which is being challenged in two lawsuits at this point in time. You know, the regulation goes into effect July 1st of next year, and we don't know what's going to transpire between now and then, whether any results will come from these lawsuits in that period, or whether any results will come from Congress in this period. There's also a lot of talk about activities and legislative activities that might take place in the first quarter of next year. But it remains to be seen whether any of that will have any effect on this regulation. And I think, you know, our point here, and I'm going to turn this over in a second, our point here is that we have to assume that this regulation will be in effect as scheduled July 1st of 2015, and that really is how we're proceeding with our work and with you know, our understanding and anticipation of this regulation. So with that, I'm going to turn this over to Catherine.
Great, thank you, Peter. What I'm going to do first is just run through a roadmap of all of the components of our talk today. We're going to start with timing issues, what the timing is for your first set of data reporting to the department, estimated timing for issuance of the first debt to earnings rates by the department, and we'll talk about the transition period. We'll talk in an overview about what the debt to earnings metrics are. We'll talk about what a GE program is, how to determine the applicable cohort, which you need to have to determine your annual loan payment and earnings. We're going to dig into the actual definition of annual loan payment, annual earnings, and discretionary earnings. We'll talk about the transitional rates in more detail, the certification requirements, and then give you some compliance recommendations. We know that institutions are trying to prepare updated projections of what their rates may look like, so we're going to give you some recommendations about how to do that. We think that's a very good idea. Many institutions are already doing it, but we recommend that you do so to supplement whatever is already out there from the department's draft rates and other information on potential impacts. First, I want to start with the slide on timing considerations. If you look at the third row down, we'll start with that, and you'll see this slide later on, and I'll focus on the right side of the slide later. But for now, let's look at the 2014-15 year, which is the first award year for which the department has said it's going to issue debt to earnings ratios under the GE rule. We'll talk about those rules those metrics in detail. But to issue those rates, the department needs to have earnings data for the students within the applicable cohort for calendar year 2014. The department has indicated that it does not plan or does not estimate to be receiving that earnings information from SSA until February of 2016, which means a rough estimate for issuance of draft rates would be the spring of 2016, issuance of the notice of determination of final rates being later in 2016. So that's the estimated rough timeline, not taking into consideration any potential delays due to what Peter talked about. I think an area where we might see some slippage is with regard to the issuance of the draft rate, just knowing that this is the first time that the department has done this with regard to the earnings data, and there may be some hiccups with respect to the months that they take to actually issue those draft rates. So that is an overview of the timeline. We've indicated on the left, we're assuming this is a chart for the 2-year cohort. It doesn't include categories of cohorts for the 4-year categories of cohort, which we'll talk about. So this is the general estimation of timing considerations. Now looking at the debt to earnings rates themselves, which are really the heart of this GE rule. The way this is going to work, and many of you are already very familiar with this, is that each GE program offered by an institution will be receiving a calculation for each award year for an annual earnings rate and discretionary income rate for the applicable 2-year or 4-year cohort for each GE program. Now, the status for each award year for that program will be as follows based on these thresholds. The program will pass if the annual earnings rate is less than or equal to 8%, or the discretionary income rate is less than or equal to 20%. Will be in the zone if the annual earnings rate is greater than 8% and less than or equal to 12%, or the discretionary income rate is greater than 20% and less than or equal to 30%, or will fail if the annual earnings rate is greater than 12% or the denominator of the rate, the annual earnings, is 0 and the discretionary income rate is greater than 30%. So that's an and there for the fail. These are the thresholds for determining the status of your GE program for the award year. Now, in terms of consequences of that, we'll go to the next slide. So ineligibility is triggered if a GE program becomes ineligible to provide Title IV aid for 3 calendar years if it fails both of the rates in any 2 of 3 consecutive award years for which rates are calculated, or it is in the zone or a combination of zone or failing for 4 consecutive award years for which rates are calculated. Basically, the department has taken the position that this 4-year zone eliminates variances in the economic cycle and one-off combinations of students that may result in a failing program in any one year, and that this 4-year period levels that inconsistency out and reduces the likelihood of failing a program that shouldn't fail to 0. And so that's why they've advocated for this zone period. Now, we'll look at the debt to earnings rate. The first metric is the annual earnings rate. And the definition of the annual earnings rate is the percentage of a GE program's annual loan payment as compared to the annual earnings of students who completed the program. And so as calculated under the new rule, that calculation is annual loan payment over annual earnings. And we're going to talk about annual loan payment and how that is defined. Now, the department has these two distinct metrics, annual earnings rate and discretionary income rate. And they view the annual earnings rate as more accurately assessing programs with graduates that have low earnings, but also relatively low debt. And so it serves a different purpose in their mind than the discretionary income rate. For the denominator here, the annual earnings, and we'll talk more about this, the department obtains this data from the Social Security Administration, obtains mean and median earnings from the Social Security Administration, and uses the higher of the two for purposes of the calculation in both the annual earnings rate and the discretionary income rate that we'll talk about next. So for example, for award year 2014 to 15, the department would be using 2014 Social Security earnings data. The second metric is the discretionary income rate. And the department views this rate as capturing programs for students that have higher debt but also relatively higher earnings. Now, this is defined as a percentage of a GE program's annual loan payment compared to the discretionary income of the students who completed the program. So as calculated under the rule, it's the annual loan payment, the same numerator as the previous metric, over discretionary income, which is the annual earnings, also used in the previous metric, minus 1.5 times the poverty guideline for a single person living in the continental U.S. So the Secretary applies the poverty guideline for the calendar year immediately following the calendar year for which the annual earnings are obtained. For example, for the 2014-15 award year, the Secretary uses 2014 SSA earnings data and the 2015 poverty guideline, which reflects price changes in 2014. That was just an overview of how these metrics work, and we're going to break it down further. But now we want to talk about, before we can apply the metric to your particular programs, we need to first decide what is a GE program, and Steve will pick up on that topic. Steve?
I'm sorry, everybody. Thank you, Catherine. This slide's entitled, "What is a GE program?" We probably could have called it, "Do I have any GE programs?" The answer to that is probably yes, since nearly all programs at institutions in the proprietary sector are GE programs, and the only outliers being approved liberal arts programs, and most non-degree programs at public and private nonprofit institutions like community colleges are GE programs. The interesting clarification that we've gotten since the first GE regulation was passed is actually on this bit that applies to the non-degree programs at public and private nonprofit institutions. There's actually been guidance on this. You can find it on the department's Gainful Employment Information webpage on the department's website. But essentially what the department has said is, okay, if you've got a 2-year non-degree program at a public or private nonprofit institution and you award no credential for it, then it is not a GE program, provided that it's also all credit that would transfer into a bachelor's degree program. However, if that same program did award a credential, it becomes a GE program. So that's really the tipping point, is do you have a credential awarded for these transfer programs? If you are a nonprofit or public institution. So now that we know that most of us have GE programs, how do we identify them? Well, you can think of it this way. Each GE program has an address, and that address is the first 6 digits of the institution's OPEID number and the 6-digit zip code that is assigned by the institution for that program. And you can go ahead and skip to the next slide, Catherine. So you'll find that zip code is actually on your e-car, the page for approved programs. It may also show up on program approval literature that you get from your accrediting body or state where you might have to register or seek programmatic approval for the programs you offer. But at any event, you can find the entire SIP at this link on top of slide 10 there, nces.ed.gov. It's because the SIP was developed by the Department's National Center for Educational Statistics. What it is a taxonomy of instructional program classifications. We'll talk a little bit more about that in a minute, but essentially the last thing we want to say on this slide is that you are under a obligation currently to identify a SIP code for your programs, and it's not a bad time to review what's on your e-car to make sure those SIP codes are accurate. Okay, and the reason the department cares about SIP, at least as far as it pertains to gainful employment, they have other reasons that they care, but the gainful employment reason is that it helps them zero in on the recognized occupation for which your program is supposed to be preparing students to be gainful employed in. They get to that point by taking a look at the SIP code, which will correlate to standard occupational classification code, which is another taxonomy. This one, instead of being for educational programs, is for occupations. And SOC is actually was the government's first taxonomy. They now have essentially replaced it with something called ONET SOC, which is run by the Department of Labor, Bureau of Labor Statistics, and that is all online. But what you'll find is that there is a crosswalk that allows you to take your SIP code and port it over to see what SOC code or ONET SOC code occupations marry up to it. As we probably all know, you've been required as an element in your GE disclosures since the first GE regulation to actually say what those ONET SOC codes are for each one of your programs and actually provide a link so that interested parties like prospective students could go take a look and understand what the program is representing that it prepares students for. The last bullet point here is sort of an interesting point that we wanted to make clear is that at the moment you're not under any obligation to report SOC codes, just SIP codes, but the department seems to have reserved the right in the future to reconsider this. And if you think about the reasons why they might want to, as we talk more about how the overall calculations are put together and made, you're going to see that the earnings data that go into this are pulled out of Social Security data, as Catherine mentioned already, and there isn't really any way to pin it down by occupation. It's based on the people involved. I think that this last bullet point in Ed's statement in its final rule discussion is hinting at where they'd like to go in the future, which is trying to find a way to make sure not only that students have affordable loan payments based on the jobs that they have, but that those jobs are actually the jobs that the school said that they would have. Okay, go ahead and take us to 12, Catherine. Okay, so because of this 12-digit address that I referred to earlier, the way that GE programs are identified and the way that the GE rule sets this up, basic distinctions like is a program taught at a main location or one of that main location's branches are essentially irrelevant to the calculation of debt to income ratios for those programs. They're going to do it simply based on whether that address covers a program that might be offered at a main and a branch at the same institution. When that's the case, you're going to see that the 6-digit SIP and that 6-digit OPEID, when put together, cause you to have just one program. It could be taught in multiple places. It could be taught 100% online. All of these other bullet points here will sort of give you examples of when you do or don't have multiple GE programs. For instance, programs that have maybe the same 6 SIP, but a different and same 6 OPEID number, but have a different credential level, a certificate versus a degree. Those are separate GE programs. But if those three elements are the same, you're just dealing with one program. Finally, we have an obligation to update our electronic applications when we have changes to a GE program, and these are, some of these are new requirements beyond what has currently been in the law up till now. The loss of eligibility of the Gainful Employment Program, changing the Gainful Employment Program's name, importantly, a change in what we think the proper SIP is, or if a program goes from a non-degree to a degree credential level. All those things would change, not whether or not it's a gainful employment, but whether or not other offerings at the same institution, are different in comparison to, the program that has experienced this change. Okay, let's go to slide 13. So I mentioned that I wanted to talk just a little bit more about SIP, and the reason why is that the rule provides that institutions are prohibited from establishing new programs that share the same 4-digit SIP code as a program that becomes ineligible, or a program that is voluntarily discontinued while it's in the zone or failing. And this is a restriction that lasts for 3 years. So you have essentially a 3-year cooling off period if you have a gainful employment program that loses its Title IV eligibility, or one that you discontinue because it's in danger of potentially losing its Title IV eligibility. And the definition of substantially similar is based on this 4-digit SIP code. And you may look at that and think that, well, that doesn't sound so bad, or maybe that makes sense, but it actually has some pretty interesting implications. As we said before, that SIP is a taxonomic coding scheme of instructional programs, and the SIP titles and program descriptions were intended to be somewhat of a generic way of categorizing programs, so that the department and other higher ed researchers can track completion data. They're not supposed to create a unique number for every specific major or field of study that could be used by an institution. And interestingly enough, and I'm quoting from NCES here, the SIP is not intended to be a regulatory device. I think it's being used like that now. But the point here is that the SIP taxonomy is really organized on 3 levels. There's a 2-digit series, a 4-digit series, and a 6-digit series. The 2-digit series, the first two numbers, represent the most general groupings of related programs. When you zoom in to the 4-digit series, what you're looking at is a group of intermediate programs that have comparable content and objectives. And I guess that's why the department thought that substantially similar fit the 4-digit series. But they could have chosen instead to limit it to the 6-digit series, which is what really represents specific instructional programs. And by choosing not to do that, by staying with the 4-digit series, they create some possible outcomes that I think could surprise people who haven't really looked at this. I'll give you the best example I could come up with. There's a 4-digit series in the SIP, 51.08, which corresponds to allied health and medical assisting services. So that is a grouping of programs that would prepare you to be a medical assistant, for instance. So let's say you had a medical assisting program at your institution, and that medical assisting program loses its eligibility. So that you can't have another medical assisting program for 3 years based on this restriction. And you couldn't have a substantially similar program either. And that would include 15 different 6-digit series in the SIP. And it would include programs that would prepare students to become pharmacy techs. It would include programs that would prepare students to become veterinary or animal health techs or veterinary assistants. It would include programs that would prepare students to become emergency care attendants, EMTs or paramedics. So you may not have thought, when your medical assistant program lost eligibility that you'd be barred from starting a veterinary assistant program, but in fact you would. Okay, Catherine, back to you.
Great. So what we're going to talk about now is the applicable cohort of students whose data is utilized by the department to calculate the debt-to-earnings rate. And as a review, for each GE program offered by an institution, Ed is going to calculate for each award year both the annual earnings rate and the discretionary income rate. And they'll do it for the applicable 2-year or 4-year cohort. And I'll talk about that definition in a minute. And these are of the Title IV aided completers within those cohort periods. So the debt and earnings data of those students is what is utilized in those two debt to earnings rate calculations. A student under the GE rule is defined as any person who received any Title IV funds for enrolling in the program. So not for prior programs, but for this particular program that's being measured. And that would include both Pell Grant and federal student loans. So it's not just loan debt, it's also grant money. How this is going to work is the department is going to create a list of students who completed the program during the applicable cohort period from the data reported to Ed by the institution. And the list will indicate whether the list is of students who completed the program in the 2-year cohort period or in the 4-year cohort period. And it will also indicate which of the students on the list is excluded from the calculations under the authorized exclusions. Now, these exclusions include items that you're familiar with as from an institutional level because many of them mirror the cohort default rate exclusions. But the exclusions include students, one or more of students' Title IV loans that were in military-related deferment status at any time during the calendar year for which the Secretary obtains earnings information. In other words, that student was not fully available for work during that period, and thus shouldn't be, their earnings information is not fair to include. The other areas of exclusion are, number 2, one or more of the students' Title IV loans are under consideration by the Secretary or have been approved for discharge on the basis of total and permanent disability, or the student was enrolled in another eligible program at the institution, so in other words, is not working but is continuing their education. Other exclusions include, for undergraduate programs, the student completed a higher credentialed undergraduate GE program, or for graduate programs, the student completed a higher credentialed graduate GE program at the institution. So for these categories, the debt will be attributable to the completed higher credentialed program. The 6th is the student who has passed away and should not be included in the data. So let's look at the 2-year cohort period definition. This cohort includes Title IV aided completers in the 2 consecutive award years that are the 3rd and 4th award years prior to the award year for which debt to earnings rates are calculated. The 2-year cohort period is utilized in the rates when the number of completers in the 2-year cohort period is 30 or more. But for students who are required to complete an internship with respect to their program, that would be medical and dental internships, for example, or a residency, the cohort is the 6th and 7th award year period prior to the award year for which rates are calculated. So for an example, for the debt to earnings rates calculated for the 2014-15 award year, which are the first is the first award year that we're expecting to see rates, the applicable 2-year cohort for determining completers is 2010 to 11 and 2011 to 12. And the Social Security earnings data will be from the 2014 calendar year. For the 4-year cohort period, this cohort includes Title IV aided completers in the 4 consecutive award years that are the 3rd, 4th, 5th, and 6th award years prior to the award year for which rates are calculated. For an example, for the debt to earnings rates for award year 2014 to 15, the 4-year cohort period is award years 2008 to 9, 9 to 10, 10 to 11, 11 to 12. And this is utilized, the 4-year cohort period is utilized when the number of completers in the 2-year cohort period is less than 30, and when the number of students completing in the 4-year cohort period is 30 or more. Again, for students required to complete a medical dental internship or residency, the 6th, 7th, 8th, 9th, and 9th award years prior to the award year for which rates are calculated will be utilized. For earnings, it will still be the 2014 calendar year earnings. Institutions will have the opportunity within 45 days of being provided this cohort list from the department to analyze it, review it, compare it with the information they have, and propose corrections to it. And the Secretary, if the department agrees, will change that list of students to be included in the cohort. The department does not issue draft or final rates for a GE program if After applying all the exclusions, there are fewer than 30 students in the 2-year cohort period that completed in the 2-year cohort period and completed also less than 30 that completed in the 4-year cohort period. In that case, the GE program will maintain the same status that it had in the previous award year for which rates were calculated. So if in an award year it had a pass, but then in the following award year no rate was calculated, it maintains the pass status. The important thing to note here, as the department has pointed out in the preamble, if the program failed in that first award year, then had no rate calculated in the following award year, it maintains its status for purposes of disclosures as a failed program, so the warnings that they require have to be issued. After 4 or more years of no rate calculation, the department will disregard previous debt to earnings rates and will reset the program because they no longer view the prior rate information as valid or accurate. But there's a continuation of that previous status for the prior award year for which rates were calculated into the next award year following the year for which rates weren't calculated. So it's important to understand that for purposes of ineligibility determination.
All right. So
the next section, yes, go ahead, Steve.
Okay, thanks, Catherine. I think we've got hopefully a good handle on who it is that's being measured here. So let's shift our focus to what it is that's being measured. And that starts with the annual loan payment. We showed you a slide, very much, I think, second or third one in the deck here today, that you can understand the debt to earnings ratios as a fraction. And in that fraction, the annual loan payment is the numerator. The annual loan payment is something that is going to be calculated for you by the secretary or by the department. And they'll do that by determining the median loan debt of the students who completed the program during the cohort period, based on the lesser of 2 different sets of numbers. It's either the actual loan debt incurred by each student, or alternatively, the total amount of tuition and fees assessed to the student for the student's entire enrollment in the GE program, and the total amount of allowances for books, supplies, and equipment included in the cost of attendance for each award year the student was enrolled in the GE program. So just to emphasize that for a second, it's not what they actually spend, it's what was allowed for it in your COA. And so in that way, you've got a cap on what this untreated about to be annual loan payment number is. The ceiling would be what is in this little paragraph B. But before you just plug that into your fraction, you would have the option of having removed the highest number of loan debts that correspond to students who the department goes out to SSA to get loan data, or earnings data rather, from, and is told by SSA that there's nothing they can report. In other words, if the department gets a report back from Social Security that student A and student B didn't have any, they weren't able to find them in SSA's database, then what the department would do to offset that is to eliminate the students with the 2 highest debt amounts from the cohort. Then after making that adjustment, they calculate the median of what was left. Okay, so in calculating this actual loan debt, the secretary is going to take into account 3 different buckets of debt. The first is the amount of Title IV loans that the student borrowed, which is your total amount dispersed less any cancellations or adjustments. This is all going to be in NSLDS for enrollments in that GE program. So what we're telling you here is that the Federal Plus loans that might have been made to a parent of a dependent student, and direct unsubsidized loans that were converted from teach grants, those don't go into this calculation. The second bucket is any private educational loans, as is defined in the regulation. These are the ones for which that you have to make the required truth in lending disclosures. So these are loans that the student borrows for enrollment in that particular GE program, and are subject to your reporting in the GE reporting requirements. The third bucket is pretty much anything else that the student might owe the institution. And we're saying it's the amount outstanding as of the date of the student's completion of the GE program on any other credit. And literally they're defining credit as any balance that's owed. So this can be an institutional payment plan that, because of its structure, maybe isn't a private educational loan. It could be a library fine. It's really that broad. So it's something to take into account, when you're trying to do your own factoring. Don't forget that things that might not strictly be loans and as defined in any of these regulations still could be loan debt. Now, there's also a loan debt attribution rule in the new regulation, and the way that this works is that the secretary of the department will attribute the loan debt incurred by a student to an undergraduate GE program at the institution. If you have a student that's in attendance and ultimately completes a series of programs at your institution with differing credential levels, all of the loan debt is going to be attributed to that highest credentialed one. And if you think about what Catherine was telling you earlier about how students who would otherwise be in a cohort for GE purposes get excluded if they're actively enrolled in another program, well, this sort of is the counterpart to that. You get since you wouldn't be counting that student because they're not employed, all of that loan debt winds up getting attributed to the higher credentialed program. The secretary will exclude loan debt incurred by the student for enrollment in programs in other institutions. So it's important to remember that what we're talking about with this attribution rule is that it's when there are multiple programs within the same institution or at an institution that shares common ownership or control with your institution. Okay, and Catherine, I think let's skip 25 and go to 26 and 27, and then we'll come back to hit this one. Once the secretary has decided, or the department has decided what your annual loan payment is, they're then going to apply the appropriate amortization period to it. So for undergraduate certificate programs and post-baccalaureate certificate programs, as well as associate degree graduate certificate programs, each one of those types of GE programs at that credential level would have their loan debt amortized at a 10-year repayment period. Bachelor's degree and master's degree get a 15-year period, and doctoral and first professional degree programs are subject to a 20-year repayment period. And in calculating this, once the annual loan payment, you're going to amortize it and apply an interest rate that is the average of the annual statutory interest rate for federal direct unsubsidized loans that were in effect during either the 3-year period prior to the end of the cohort period for undergraduate certificate, post-baccalaureate certificate, associate degree programs. For these programs, the secretary is going to use the federal direct unsubsidized loan interest rate applicable to undergraduate students. Keep in mind there's a graduate rate and an undergraduate rate. So of course, when you're talking about graduate programs, master's degree programs, first professional degree programs, the graduate rate is going to apply. They'll use a 6-year average instead of a 3-year average for bachelor's degree programs. And finally, they'll use a 6-year period prior to the end of the cohort period for doctoral programs and first professional degree programs. So, and again, it's always based on the federal direct unsubsidized loan interest rate. So now that we know how this annual loan payment rate gets calculated, let's zoom back to 25 so we can talk about what it is, if anything, you can do about it. what will happen here, and we've mentioned this a little bit before when we were talking about how the cohorts are made, but you will get a draft debt-to-earning rate calculation and debt-to-discretionary earning rate calculation. And at that point, we think it'll probably be in the spring. At that point, the institution has the option of challenging the accuracy of the loan debt information that's used to calculate the median loan debt. And you'd be doing that by providing evidence to show that the department somehow got it wrong. And there's really probably only two ways to do that. You're showing them either that the list of completers that they used was wrong for some reason, or that the level of debt, the amount of debt that they came up with is inaccurate. There are some pretty important timeframes to keep in mind. You have to make these challenges within 45 days. If you miss that 45-day period, you've effectively waived your right to challenge it, and the draft rate will become final. Similarly, if you have a right to challenge or to appeal if your gainful employment program is failing or in the zone, and this would be appealing a final rate based on filing an alternate earnings appeal. In the proposed rule, there was a second basis of appeal. It was something called a mitigating circumstances appeal, and it had to do with having a small number of Title IV students, or students who had Title IV who completed, but the department got rid of that in the final rule. So it's now all just based on alternate earnings. If you want to pursue that appeal, you need to notice the department no later than 14 days after you get your notice of determination of your final rates. And that starts a clock by which you have to submit your final documentation consisting of your appeal no later than 60 days from getting that notice. And that is going to be pretty tricky for a number of reasons. I think, depending upon how you want to pursue your appeal, you have a couple of options. One is that you could be using an institutional survey that went out and got different earnings from using an actual survey form that has to be in a methodology that's approved by NCES, and the department has said that they will be providing a sample form for you to use. So when that happens, you could take that form, circulate it to students and employers to try to get responses back to show that the department's earnings through SSA were incorrect. That certainly is going to take some time to get responses back. So the 60-day period indicates to me that if you think that you're going to fail, and you would probably have a pretty good idea of this when you get your draft rates, you need to be working on that survey as soon as possible. In fact, if you are doing your internal analytics, you'll probably have an idea that you might be on the brink, and you can start trying to collect that data for your appeal even in advance of getting the draft rates. But surveys aren't the only way that you have to challenge the department's SSA earnings. Your other option, at least theoretically, would be to obtain data that would come from a state-sponsored data system. The states track wage and earnings information for a variety of reasons. At this point, it's not clear whether there are a lot of states that today have a database that would be useful for this purpose, because what you're going to need to be able to do is to actually get data for each one of the individuals in your cohort, or at least you'll be asking for earnings information for each one of those individuals, and you need to get a response back for more than 50% of those non-excluded completers in the cohort, and that cohort itself has to have a number greater than 30. So, and if you're relying on state data, two things, that the data has to be there at the state level, and you have to have access to it, and they have to turn that around to you, within those time frames. So again, if you have, alarm bells going off based either on your internal analytics or based on a draft rate, you need to try to find out, what information your state is willing to share with you, so that you might be able to assess it for the purposes of an alternate earnings appeal. So I've mentioned already that we think that it's really important that you're doing your own temperature checks on gainful employment, really starting now. It's not too early. So by understanding how the department's going to arrive at their calculations, you need to try to use the data that's available to you to try to create reliable projections so you can have a sense of how close to the line are you, and do I need to start thinking about the possibility that I may need to get alternate earnings information, or at least be aware that you need to know how these how the calculations will be made so that you can be in a position to challenge incorrect debt levels or composition of the cohort. So you can do this by determining who those students are. Should be relatively simple based on how we've broken it down so far in this presentation, and you can determine that median either by trying to arrive on what you think that actual debt number is, or using that that capped amount of tuition, fees, and allowances for books and equipment, and then apply the appropriate amortization period and interest rate.
Great, thanks, Steve. I'm going to take the next 5 minutes to go quickly through the next set of slides, and luckily it gets a lot more straightforward with respect to the remaining components of the metrics, and then we're going to open it up for questions and answers. So please think about what questions you want to ask about any aspect of the GE rule, including the disclosures and the certifications. But the annual earnings component of the metrics is the denominator of both metrics, and this information is provided by the Social Security Administration. The SSA provides the Secretary with the mean and median annual earnings of the students who completed in the applicable cohort, and the Secretary chooses the higher of the mean or median. If the SSA, is unable to provide the mean or median for the program, for that award year, the program doesn't have a GTE rate computed by the department. So this is another category of program that would not be getting rates calculated potentially for a year. In terms of being able to project annual earnings, you don't have access to the SSA information, obviously. These are some areas where you might try to get as close as you can to the estimated earnings for the students in your cohort. Obviously, actually being able to get that salary information from surveys is ideal, but your connections with employers in industry that have information on salary levels for the recognized occupations for which you prepare graduates, for students, that would be ideal as well. The GE informational rates are somewhat instructive, although very dated and limited, but can be adjusted. And we note that BLS has earnings information, salary information for occupations, but it is not, as the department went in great detail about, is not ideal for purposes of projection. And we would just urge you to use caution if you're just going to be looking at BLS earnings, because it may be overstated for purposes of your program. Discretionary income is straightforward. It's using the annual earnings minus the poverty rate, the poverty guideline times 1.5 for a single person. We touched on this before. It's a very straightforward calculation. Transitional rates are provided by the Secretary if the program is in zone or fail status, and what that does is disregards the students in the 2-year or 4-year cohort and looks at the students who completed the program during the most recently completed award year. So for award year 14-15, the Secretary would look at the data from completers in the 14-15 award year. This is a temporary transitional period. The next chart shows the years for which this transition applies, 5 years for all program lengths, up to 6 years for programs between 1 and 2 years, and 7 years for programs more than 2 years. Again, this is an attempt by the department to ease the schools into this new rule and allow for immediate decisions that would reduce tuition or debt load of students. Certifications, we're not going to have time to go into this in detail, but we just want to note that the department was very clear in its preamble that they view certifications as an equal component to the accountability part of the GE rule, and that I'm going to flip to what they've said about the enforcement risks related to certifications, that they view the institution's certifications with respect to GE programs meeting state requirements for licensing, state authorization, accreditation requirements as being a very important accountability metric, and misrepresentations or errors in what the institution is saying about their programs have a potential for enforcement action, not just by the department, but by third parties, including under False Claims Act cases. So this is an area not to take lightly, and take a close look at your certifications and the status of your programs with respect to accreditation status, programmatic and institutional, and the state licensing issues.
Peter, Catherine, I'm thinking maybe why don't we just open up for questions now. I have a feeling we'll be able to weave these bullet points on 38 and 39 into our answers pretty easily.
Yeah, that sounds like a good plan.
Perfect. So we'll go ahead and start the questions. Our first question is, do you know what the initial institutional draft rates for GE measurements will be released to the institutions?
We, I think it's the second or third slide, we put a chart up that showed that our estimate is for the spring of 2016. But just with, because that is based on the fact that the department is not going to get the 2014 earnings data from the Social Security Administration until it's estimated to be February of 2016. So they'll have to put the draft together based on that, and that would mean, you know, March forward in terms of 2016. It could slip. This is the first time they've done these calculations, but I think the earliest is reasonably spring of 2016.
Okay, thank you. Next question. I thought the final rule eliminated the different credential level as a way to establish a different GE program.
I'm not sure I understand the question.
Maybe I'll have them retype their question and we'll go on to the next one. Will institutional draft numbers be public when they are released?
I don't believe that the department has said that draft numbers would be published. It seems a little inconsistent with how they handle cohort default rate drafts. So I'm guessing that, you know, as non-final numbers that they probably won't release them. But you know, there isn't a definite answer out there.
Okay.
Jenny, going back to the previous question, I think that the questioner may have been talking about when a program is deemed substantially similar for purpose of establishing a new GE program. And in that case, the credential level has been disregarded, and it's just the 4-digit zip code that's looked at. That may have been the direction of that question.
Okay, thank you. Next question. Does the Title IV loan debt include living expenses disbursed to the student, or only the actual amount paid toward all educational costs?
Well, the loan debt, you know, when they're calculating, you know, actual loan debt, you know, they will take into account, you know, the Title IV, you know, dispersed. But, you know, because your ultimate exposure to as an institution for the, you know, the annual debt of this cohort is capped at tuition fees and allowances for books, supplies, and equipment. You know, the debt level, the annual debt amount and the monthly payment that, you know, flows from that should not take into account living expenses, because, you know, that is something that, you know, is outside of, you know, what is capped in that cost of attendance.
Okay, next question. Will private loans be included in the annual loan payment if the loan balance has been written off by the school, so the student would no longer be obligated?
I suppose it would depend on when the institution takes that action. If they did it the day after the student completed, I don't think it would make a difference. I think that you'd still be reporting as of the date of completion that the student had that institutional debt. However, if the institution forgave the debt on the date of completion or the day before, I think you have an argument for not including it.
Okay, next question. For the purpose of other credit, I assume that this is to include unpaid account receivable, if any, that student owes the school upon graduation, correct?
Yes, that's correct.
What effect would there be if the student does not pay it and school does not attempt to collect it?
You know, I don't think that would help. You know, they're going by just definitions of what is credit that's been extended, what is educational debt. So, you know, I guess if the argument is, well, we never really tried to collect it, so, you know, therefore it wasn't really debt or we forgave it, I think you need to actually take it off the books, let the student know prior to completion or possibly simultaneously with completion that, you know, those are not, you know, amounts that the student's obligated to repay. But I don't think you could rely on your own conduct as a way to try to reduce debt after the fact.
Okay. How will ED determine interest rate and payment rate for private loans or amounts owed to the school?
They don't. This is where it gets a little unfair because, you know, a lot of institutions, particularly with institutional payment plans, I'm seeing a lot that charge minimal or zero interest. But the way that this works is all of that debt, whether it's Title IV debt or institutional debt or, you know, private loan debt from a third party, gets aggregated and amortized using that, you know, federal direct unsubsidized interest rate, which is either that 3-year or 6-year average, depending upon the program you're dealing with. So that means that if you had if some of that loan debt actually was at a lower interest rate, that you're getting a higher rate of interest imputed to that debt, and that's not fair. But the department is resigned itself to the fact that this is, you know, part of the way this is going to go, and they think that the injustice of all this is offset partially because of the ability of institutions to cap the ultimate loan debt to what are, in the department's opinion, areas that the institution can control, namely its tuition, its fees, and its allowances for books, supplies, and such. The other answer that they gave was that they didn't think that there really was a whole lot of that out there, but my anecdotal evidence is to the contrary.
Okay, next question. What is the school's reporting responsibility?
Well, by July 31st of 2015, the institution has to report all of those categories of data that are included in the final rule. And that July date goes on for a couple of years thereafter and then converts to an October 1st deadline. But there are these additional categories of data that are spelled out with great specificity in the final rule that the institution needs to provide to the department by July 31st.
Yeah, and then there will be a 2015 is kind of a big year for reporting in the sense that you're going to do this July 31st reporting for a number of years, and then for the 2013, 2015 period, you're also going to have an October 1 report. So it's unique in that you'll have 2 separate reports that year. Thereafter, as Catherine said, it gets normal at October 1st.
Okay, I think you might have answered this early in the presentation, but I'll ask it again. How is the institutional loan debt calculated? Is it remaining balance owed? If so, as of what date?
It's the amount borrowed, similar to, well, I should say amount dispersed. So, if it's possible that there are institutional loans that, for instance, if you had an institutional loan that was canceled, that would not count. but it's going to be treated similarly to Title IV loans. So they're going to go by amount dispersed, less any returns or cancellations.
And it's determined as of the balance as of the date of completion.
Okay. And this was regarding the failing metric. Does this mean if the program fails the first and third year of a 3-year period, the program becomes ineligible? Is the 3 years the most recent 3 years, or is the failing years need to be consecutive?
The 3 years need to be consecutive, and the program has to fail in 2 of those 3 years.
Yeah, for which rates are calculated.
For which rates are calculated.
That's where it gets complicated, right, Catherine? Because if you have a program where you don't have enough completers, that even with the 4-year period to do a calculation, then it's like that year never happened, but your status doesn't change. So you could have a period of time where you don't have consecutive years, but 2 out of the 3 years that are calculated fail, and you'd fail in that circumstance.
Okay. It was my understanding that alternate earnings challenge could come from local or state information such as labor statistics, etc. Based on the presentation, are you saying that the local or state information has to be from or more accurately about the individual?
Yes. Yeah, the expectation is that if there is a database out there that is picking up or doing a better job of picking up earnings than Social Security, you're going to be providing data on the same people. That's going to be the basis of your challenge. You're going to say, well, Social Security got it wrong. Maybe these individuals misreported something to Social Security, but the state says they earned X when Social Security says they earned Y, and we want to go with X because X is a bigger number. It has to be, it has to relate back to the same individuals in that cohort. In terms of predicting where you stand, there are state databases out there, just like the BLS data, and it's been suggested by some that you can use that those state databases that you can run searches on that don't get to individual level data might have value over BLS because you can sort of zero in on a geographical area, but you couldn't use that type of data, that sort of generic data, for an alternate earnings appeal.
Okay, next question. When an institution reports outstanding student balances to the Department of Education for calculation, should it only be for students that use Title IV or just Title IV debt? What about students that have institutional debt but not Title IV debt?
Well, a student who did not receive Title IV is not considered to be a student for GE purposes. So you wouldn't include any data on someone who doesn't. Well, actually, I'm saying that it wouldn't factor into the calculation. I'd have to take a second look at what the reporting requirements are, but I can tell you with certainty that that student doesn't get picked up in the calculation. The department may have other reasons to want you to report it.
Okay. With the regulation taking effect July 2015, a 4-year program will be evaluated on data from which preceding years?
Well, so we're talking about the 2014, 2015 award year, Jenny? Is that the part of the question?
Well, they were just saying that with the regs taking effect in July of 2015, they're wondering what the 4-year program would be looked at.
Yeah. Well, if it's a gainful employment program, but not a medical and dental program, and you have 30 or more completers in the 2-year cohort period, that for the award year 2014-2015 calculation, which would be the first one that we anticipate getting sometime in 2016, that would cover the award years 2010 to 2011 and 2011 to 2012. That's the 2-year cohort period. You would expand to a 4-year cohort period if you didn't have 30 completers when you looked at those first two. So in that expanded cohort period, you just look back to the fourth and or the 5th and 6th cohort years. So that would go from award year 08-09, 09-10, 10-11 through 11-12.
Okay, next question. I think this is saying if you have a medical assisting, a diploma, and associate degree, if the institution offers both, are these 2 different GE programs with 2 different calculations? So I think they're asking if they have medical assisting diploma and a medical assisting degree. Are those 2 different GE programs? Are those considered 2 different programs?
Yes, because the credential level is still part of the definition of gainful employment program. So that definition is it's an educational program identified by a combination of the institution's 6-digit combination of the OPID number and the 6-digit zip code assigned by the institution and the program's credential level. So even though you would have that 6-digit OPEID number, 6-digit SOC number matching up for those 2 programs, the difference in credential level makes them separate GE programs.
Okay, is there any projection as to when the department will provide record layout requirements for reporting?
I have not heard anything about timing on that. Have you, Steve?
I haven't. I mean, we were asked. I was asked that on a previous webinar. Actually, they wanted to know when the manual was coming out. Certainly there will be, I think, pretty significant guidance on how to do this, but I haven't seen anything from the department yet. It's probably on the way, but considering July 1 is still a ways off. Stay tuned.
Okay, if the first draft rates won't be until spring of 2016, how did the department make their projections on ineligible programs and students?
They did that, and I assume the person asking is wondering how the department makes the claims it does in the discussion in the final rule. And the answer to that question is that the department used old data from their 2012 informational rates. So it's not actually a completely accurate data set that they were using, but based on that was their analytical model. So when they say X% of programs will pass or be in the zone, they're making that claim on the basis of having sliced and diced that 2012 informational rate data set.
Okay, if during the transition period the look-back cohort is greater than 30 students, but the current year, the transition year, is less than 30 students, can the transition year numbers count for testing?
That is a great question, but I would have to look it up. I don't have that answer off the top of my head.
Yeah, I think you stumped the panel on that one.
We can go ahead and answer that offline then and send it out as an email. we still have quite a few questions coming in, so I'll just go ahead and keep going. But once again, I will be emailing the PowerPoint and or a link to the PowerPoint presentation, recording, and PDF out tomorrow. So next question, will institutional official GE numbers be made public when they are released?
Yeah.
They will be, and if you appeal a failing or a program with a rate that will subject it to sanction, the public disclosure for that program will still be that a final rate was calculated that was failing, but that the institution has appealed it. Also, since I didn't get to say this during the presentation, the effect of an appeal is to stay any sanction by the department. So I mean, it keeps your program eligible while the appeal is pending.
In the preamble, the department also said that they're going to post on their website the mean and median earnings information, both mean and median earnings.
And I would expect too that the trade press like the Chronicle of Higher Education and Inside Higher Ed may be and certainly other outlets like the Huffington Post will probably be doing articles about the time that information becomes public. So it'll probably get spread around quite a bit.
Okay. This is an interesting question. For an individual who owns their own business and doesn't draw a salary but takes dividends from their business, how will SSA count their income?
It's a huge weakness. I think the problem is that the SSA is going to show what is the net income of this of such an individual, which probably means that their earnings rates are going to be understated from the perspective of reality. This is something that's part of the discussion in the final rule, and the department kind of punted on it, saying that they understood that this could be a problem, but they didn't think it was going to be that big of a problem. It's really where if you're an institution where that a lot of your students are independent contractors or going into business for themselves, I think this is something that particularly like cosmetology programs might have. That's a great reason to work very hard to establish relationships with your alumni, so that you're getting some of this information reported back. I think we're in the education business, which is a relationship business, and I think that there are a lot of reasons why you want to have positive alumni networks, but this is a really big one for proprietary schools in particular. I mean, in the past, you don't do a lot of development and fundraising, so there has been, I think, less of an emphasis on really keeping up with alumni once placement statistics have been verified. But with gainful employment, you're going to have a need possibly to be talking to students 2, 3, 4 years out from graduation, and having them understand the need for this data. And you can also tell them that will be confidential. It's only going to be shared with the department to the extent that it's reported. It's an aggregate. It won't be back to them. So that may be what you need to do to get the real dollars, because you can count on SSA not being able to give the department the right statistics.
Okay, I think this is another common question. If a student comes to us and has completed education at another school, are their loans from that school included in the calculation for the current school?
They would not be under that attribution rule unless the other school was under common ownership and in control with yours. You should the debt only gets attributed to programs that are completed at your institution, or at another institution under common ownership and control.
Okay. Someone asked if we will be able to send the Q&A information along with the PowerPoint. I can see what we can do about that and get that out. Otherwise, it will be in the recorded document of the webinar. So the next question, any guidance on conflicting CIP codes over the time periods and students in the transitional period?
So the idea is that if you make a change in your SIP code while you're in the transitional period, that would result in two different GE programs essentially. How does that get handled? You know, all I can say is that, you know, at the moment, the institution has the ability, or it's, you know, the prerogative of the institution to designate what SIP corresponds to which program. So you certainly have the right to make changes. It might be in everyone's best interest to, you know, review all of their designations that are currently on ECARs in advance of the first wave of reporting, so that you can avoid a complex situation.
Right, and after July 1st, 2015, the effective date, you have to report on your EAP any SIP code changes within 10 days. So that's an additional, you know, obligation that kicks in on July 1st.
Yeah, and I would presume, this is just speculation, but that, you know, the reason that they want that update is so that they can track those changes, so that you know, they're able to evaluate programs even though you do a SIP change as the same program.
Okay. Will the department provide a template or the report, or will the report be submitted via NSLDS?
I guess we don't know yet exactly how this is going to happen, but hearkening back to the previous rule, you know, they certainly did develop a process and a portal for reporting, and they had spreadsheets for that purpose. So I think it's reasonable to expect something similar in the future, but we just don't know yet.
Okay. If the ED determines loan balance and gets income from SSA, what calculations will the schools be required to provide?
You're, as an institution, going to be providing, you know, the basic inputs into that allow them to make these calculations. So, you know, it's the identity of your completers, and you know, your calculation of institutional loan debt in the sort of the large general sense that we've been talking about.
Okay, next question. If the 4-digit code group can cause an MA program to affect a pharmacy tech program, are those program groups lumped together for all the GE calculations initially, or would programs within a 4-digit group report separately?
Yeah, they're gonna have different. Well, they're probably different. And I say that I think there'd be different GE programs. You know, if you had, you know, pharmacy and veterinary, they are in the same, you know, 4-digit series for you know, ONET SOC codes, SOC codes, but you can, that doesn't mean that their SIP codes are the same. They're probably not. And remember, you know, you're dealing with you know, the OPE ID number of the institution and the SIP code plus the credential level. That's how you know, decide whether two gainful employment programs are, whether you have two gainful employment programs versus just one. Where this, you know, 4-digit SOC series comes into play is when you have a program that is subject to sanction, loss of eligibility, or if it's had failing or zone scores and you intentionally discontinue it, you're then subject to this restriction on applying to the department for approval of a new program that is substantially similar. And it's that definition of substantially similar that brings in the 4-digit series of SOC codes. So it's not that veterinary and pharmaceutical tech programs are necessarily the same gainful employment program. It's that the way this is going to be defined, they're substantially similar. So failing one means you can't add a new one. But assume you already had both, and the pharmacy tech fails, the veterinary tech program is okay, it's passing. The failure of the farm tech program, because it should have a different OPE ID plus SIP code, won't cause your veterinary program to fail. They're separate programs. You just couldn't add a new one if you didn't already have it because it's substantially similar.
All right, thank you, Steve. So we are running out of time, and we do have more questions. So what we're going to do is we will send, I'll take one more question, and then we'll send an answer to the remaining questions out through email. So our last question is probably kind of a tough one. How can the school obtain challenge data on an individual when you don't know that what income, data, or value was used for that individual? When the earnings data comes back from ED, we only see an aggregate number, correct?
That's correct, and it's one of the big controversial aspects of this rule that is subject of the litigation as well. That's right, it's aggregated data. So you can't challenge it on an individual basis. That's correct.
Yeah. So you're gonna, but you could appeal it. And the difference between a challenge and an appeal here is that the appeal is what is your last resort once you're going to lose eligibility for the program. So once you have those 2 out of 3 failing years or 4 years where you don't get out of the zone, at that point. Even without knowing exactly what SSA reported for all those students, that if you can find an alternative earning source that says you pass, you want to let the department know about it.
Okay, and so I think that's all the questions we'll take for now, and as I mentioned, we'll send out answers to the questions we were not able to answer today. So I just want to thank everyone for joining us and wish everyone happy holidays. Thank you.